You go into a trampoline park, you sign a waiver, and the walls are absolutely covered with rules and warnings. And anybody who's ever been to one of these places knows it can be an accident waiting to happen. In fact, it's estimated that over 100,000 people go to emergency rooms every year when they get hurt at trampoline parks. So when someone tries to find a personal injury lawyer because they got hurt at a trampoline park, odds are pretty good they're going to get laughed at. After all, falling down is what these places are all about. Getting hurt is just part of the fun, right? So how did a jury come to award over $300,000 for a slip and fall accident at a trampoline park? And why did the judge increase the amount to over $500,000? On February 19th, 2019, our client, a 65-year-old woman, takes her granddaughter to a trampoline park in Las Vegas. This is one of her granddaughter's favorite places to go, but our client has never been there. While monitoring her granddaughter, she tries to stop a basketball from rolling onto an air mat and loses her balance, and she falls onto the air mattress. But something goes wrong. She is then taken to an emergency room with a broken shoulder. When you watch this video, whose fault do you think it is? I mean, clearly she loses her balance, but aren't those pads meant to be fallen on?
So in this case, we did an offer of judgment to settle on behalf of our client for $150,000 before trial. So this was a case that really hung on liability. That was the main issue in the case. They were convinced that because it was her fault that she fell, they felt like that would win the day for them. So based upon their analysis that it wasn't their fault that our client was injured, they refused to accept our offer of judgment. They offered an amount to settle much less than what our offer was to settle.
In a trampoline park, you got a 2-year-old running all around, not under control or under supervision. They could be seriously injured.
At trial, the defendants argued that the injury to our client was her fault. She was completely responsible for it. And they argued a couple of things. They said that she wasn't paying attention. She was there watching her granddaughter, supervising her, which she was, and indicated that she didn't do an appropriate job, that she was distracted. She was on her phone. She was talking with her boyfriend back in New York at the time.
When I was assisting on this case, from the beginning, we were insistent that it was her fault that she fell, but it wasn't her fault that she got injured. We all agreed that the strategy was we needed to be reasonable about it while we presented it to the jury.
Then they tried to say our client fell on the wrong part of the air mat.
Even with that skirt missing, if a person jumps to the left or to the right, but to the left, since that's where that skirt's missing, they're not going to go down between the airbags. Her foot, as you can see, is going down right inside the wall. She didn't step out on the bag. This is the platform. You can tell that is a slide plane. That's the deck. That's where she was standing, and she went to put her foot right down through there.
What was important in this case was that gap between the two airbags shouldn't have been there. There should have been what's called a Velcro skirting that attached the two airbags and eliminated the gap.
And so the defendants had an expert. And through discovery, particularly in deposition, we were able to attack his opinions and his position and really lessen his credibility to where at trial the defendants did not bring him. They thought that he would be more of a liability to them than a benefit. So they didn't have their expert at trial because we were able to really eliminate him before trial. We also were able to find one of the leading experts in the country dealing with amusement parks and airbags, exactly what occurred here in this case, who as well testified that you have to have that Velcro skirting.
That's a proper connection of the Velcro flap.
When this Velcro flap is in place, and it's attached to two airbags, eliminated the gap. Does that provide any stability to this airbag?
It does. What it does is it connects the two tops. So if like me, I was standing right here, and what it does is it pulls this and it prevents you from coming into contact with the ground.
And when asked about this, well, the defense, they were adamant that this feature was purely cosmetic.
It's cosmetic, in my opinion. I haven't read the manual. It's cosmetic in nature. I2K designed the bags. And so they got two bags side by side. And so it was a way for them to make it look like one big bag.
But our expert was able to explain to the jury and to tell them convincingly that it's not only a cosmetic feature, but it's one in which provides safety to the consumer, to the guests. and it eliminates that gap so that if they fall towards the junction between the two airbags, they're not going to fall down between that gap down to the ground and potentially get injured.
So we dug into their maintenance logs and we saw that there was no record of anybody making sure that this equipment was properly set up.
They did not have any checklists, but it was mentioned in their safety manual that I talked about in my report, that specifically says, they in their manual, it says that there are inspections. The shift lead or assistant manager on each opening shift will be responsible for conducting formal daily inspections before opening to the public. So they knew based on their manuals that these inspections should have been done.
Okay.
But based on discovery, I have not seen one checklist that was completed or filled out or even blank that was part of their operation.
Whether the case is in litigation or whether it goes to trial, you can settle a case at any point in time before the jury comes back and renders their verdict. And so in this case, while the jury was out, defense counsel came to us and they made an offer to settle. And they made an offer to settle for $250,000. So more than what our initial offer of judgment was. But we had done well enough in the case to where we felt encouraged. We felt good about where we were at. But ultimately, it's the client's decision as to whether or not to settle.
During closing arguments, one of the things that I do during the trial is I watch the jury while the arguments are going on to see how they're reacting to things. And the defense attorney was making these arguments that our experts had already refuted. And juror number one seemed to get so frustrated listening to him make these arguments that he literally slammed his notebook on the ground and then threw his pen down on top of it instead of taking notes. So I figured that maybe we had good chances of getting a good verdict.
She considered everything and she decided that she wanted to let the jury come back and render their verdict. She felt good about it. And ultimately the jury came back and saw it our way and they awarded us $379,000.
An offer of judgment is a legal tool that helps you make an offer to finish the case before trial in exchange for an amount of money you think is fair. It's like saying, hey, this trial is going to take forever and be super expensive, so let's settle this now and save ourselves some money. The only reason you would reject an offer of judgment would be if you felt like the amount offered wasn't fair. But what happens if you're wrong? What if you reject an offer for $150,000? But the jury comes back and says the case is actually worth even more than that, and you were a fool for not taking the offer before trial. Well, that's what happened in this case. With the jury awarding an amount over double the plaintiff's offer of judgment, the lawyer saw it as proof that the pretrial offer was not only reasonable, but a bargain that the defendant rejected. And since the defendant rejected that offer, there was no option but to go to trial. Therefore, the costs of going to trial were ultimately the fault of the defendant not taking the fair deal when they had the chance. So attorney Scott Flinders made the argument to the court and asked the judge to award not only just the jury verdict amount, but also attorney's fees, case cost, and interest that should have been earned while being forced to go through trial. And the court agreed with his arguments and awarded the plaintiff a grand total of over $500,000. In a sense, taking a case to trial can be like gambling because you can always lose. But then again, if you bet on the right lawyer and the right law firm, well, you can also win.